All right, Truman L. Flatt and Sons v. Schupf. A suggestion for modification to a contract does not repudiate the contract. And repudiation can be withdrawn if there is no suit about the repudiation or a change in the material position of the other party based on their reliance. So in this case, these guys are buying some real estate, and the real estate zoning problem, and they go, all right, there's a zoning problem, give me a 10% price cut. And the guys come back and they tell them, no price cut. And the guys go, all right, we'll buy it. The guy goes, no, you repudiated. You sent us a letter and you repudiated. And the other guy goes, okay, did you have like another buyer lined up? It's like, nope. It's like, okay, then you have materially changed your position. So we want it. We want to pay for that land. Yeah, like which we have the right to under the contract. Which, yeah, they didn't repudiate. Saying, hey, can you change the price of something? Can we renegotiate? So say I've got an option contract for a 24-year option on a beachfront property. And I say, 24 years is a long time. Can I get a 12-year option instead? That's not me saying I'm not going to take the 24-year option. That's me trying to get a different number, which is fine. Anyway, I'm still mad about that beachfront property case. All right. And with that, I am done for the night. So quick update. Thanksgiving is coming up tomorrow night. I'm going to try to upload last week's civil procedure and then a week or two of torts. And then I'll be taking a week off. From there, I only have a week of classes and then finals. I'm going to do some like bloggy stuff after the finals. But I've said this a few times. If you guys have cases you want me to do, put them in the comments. I will go read the cases, as boring as they are, and I'll get back to you. I'm not going to read anything that's super complicated or controversial. Actually, I'll read anything complicated. I will read something controversial. No Augerville v. Hodges, no Brown v. Board, nothing like that. That's con law anyway, and I have a lot of things to say about con law, but I'm not gonna do that until I've either taken a con law course or something like that. I mean, I don't know. I guess I've taken a con law course. I'm not gonna do stuff like that, because a lot of con law decisions are, especially like the two I just mentioned, Brown v. Ward and Roe v. Wade, not Augerville. Augerville's great. I love Augerville. Great decision. Reasoning. I'm talking about reasoning here. Like Brown v. Board and Roe, both of those are good cases in their outcomes, so I appreciate them. But their reasonings are kind of maddening, especially Roe. If you've never actually read Roe and you're an attorney, go read it. Slowly, it's complicated. If you've never taken con law, it's complicated, but read it. And you'll realize how bad of a decision in terms of the actual reasoning it is. Because if I were writing that case, it's a constitutional case. You need to have a constitutional principle that they don't. They're saying right to privacy, and then they're weighing it against public interest, and that evolves over time, and they just pull a bunch of numbers out of their hat. I promise you, it's wild. Brown v. Board has a couple similar problems. They're basing, some of the decisions off of tenuous data and some other stuff. But ultimately, the problem with Brown v. Board is that it could have been a 14th Amendment case, and they made it a Commerce Clause case. And look, I want the most civil rights protection possible, which is afforded under the 14th Amendment, not the Commerce Clause. And Brown v. Board came down 9-0, and that was why it had to go Commerce Clause, was because they had more support that way. But the real correct decision would have been to 14th Amendment it, because a lot of civil rights cases, for like 20 years after it, were Commerce Clause based. And I am suspect when it comes to the relationship between Commerce Clause. And this is all postscript. You can totally leave. That is all tenuous anyway. That was me actually just doing what I said I wasn't going to do. But again, so I'm going to be moving into some other stuff, maybe out of class stuff. So again, if you have cases, leave them in the comments. I really want more cases to go over. I actually like legal reading, as weird as that is. If you want to post me a fun, stupid legal problem to go do some research on, I'm more than happy to do that. I feel like I had another thing to say. Oh, right. I'm not 100% sure I'm going to continue this in next semester. I think I started this project strong, and I think I kind of petered off these last month and a half or so. But I'm feeling pretty good about it now, so we'll see if this keeps up. If not, this has been a lot of fun. I know I don't really have a lot of viewers, and I imagine this probably get 6 views, but to those of you who actually do watch my videos, it's quite nice to know that I'm helping a few of you, and leave your nice comments below. They are nice. I do read them. I've replied to, I think, 95% of the comments I've gotten, which is to say I've replied to 19 of the 20 I've gotten on the 130 videos I've posted. That's right, I've posted like 130 videos. Anyway, hope y'all are having a wonderful time, and I hope finals treat you as well as I think they're going to treat me. All right.